Hi, and welcome back to Focal Point on AFR Talk. I am Brian Fisher, your congenial, convivial, and amiable host. And for this segment, I want to welcome you to the Constitutional Convention of the Air, where we talk about the Constitution. We talk about the original meaning of the Constitution. We talk about how it is applied and how it is being misapplied in our current culture. Now, what triggered this, and I've got a column that'll be going up at rightlyconcerned.com on this basis. We're having internet problems here around AFA, so it's taken a while to get that thing posted. But what triggered this, my thinking about this in the column I wrote, was reading about the retrial of Jodi Arias. Now, the details here are not what's pertinent to me. She's apparently guilty of murder, hung trial first time around. So they are going to retry her. This has been a very, very expensive trial to the taxpayers. They've had to cough up $2 million for the first trial, which ended in a hung jury. So now they're going to have to spend another $2 million on the retrial to defend her. This is not to prosecute her. This is to pay for her defense. And it's a murder trial, so it's expensive. And so they have to pay through the nose to provide her with legal defense. Now, here's the point, and I want you to hear me on this. I've addressed it before, but I want us to tack this down because we are to be guided by the Constitution. We are to be guided by the meaning of the Constitution. We are to be guided by the plain meaning of the Constitution. We are to be guided by the original intent of the founders. Either the Constitution means what the founders intended it to mean, or it can mean anything you want. There are no restraints, no controls. If the controlling way we understand the Constitution is not the meaning that the founders intended to give to it. Now, here's the deal. Once you understand this, tack this down, lock it into your brain. The Constitution ensures criminal defendants access to legal counsel. It does not, I repeat, it does not require taxpayers to pay for it. Now, we've seen the TV shows and the movies and all that. If you can't afford an attorney, one will be appointed for you. Now, that's not part of the Constitution. People think that it's one of their constitutional rights. It is not. This was an invention of the United States Supreme Court in 1963, the same time they were taking prayer out of schools, taking the Bible out of schools. At the same time, they were working mischief with the Sixth Amendment to the Constitution of the United States. So again, taxpayers getting ready to get soaked another $2 million to provide legal defense for this murderess, Jodi Arias. But listen to what the Sixth Amendment actually says. Most people think that you have a constitutional right to have the taxpayers pay for an attorney to represent you if you can't afford legal defense. But here is what Amendment 6 actually says, reading right out of the Constitution. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. So you weren't to be kept languishing in a jail cell for months and years on end. We've blown that one out of the tub. You have a right to a public trial, so we won't want any kind of secret tribunals, kangaroo courts where people are treated in behind closed doors. Don't want that, and we don't have that. By an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law and to be informed of the nature and cause of the accusation. So you got to be told why you're there, the nature and cause of the accusation. You got to be told clearly. You have it spelled out why you are on trial. To be confronted with the witnesses against him. So you got to be able to face your accusers in open court. None of this anonymous accusation stuff. That's one of the things that really grinds my gears about what Child Protective Services do, where they will take a child away from parents based on an anonymous tip, an anonymous accusation. And the authorities will come and remove those children from the home, and the parents have absolutely no idea what the accusation is. They have no idea what the charge is. They have no idea who is responsible for these accusations. They have not had the opportunity to face their accuser in open court. They have not been told the nature and cause of this action. That's completely, flatly immoral, unethical, and worse, or well, not worse, but it's also unconstitutional, and therefore it is flatly illegal. Our system, and remember, this is a right that belongs to us as individual American citizens. If you are accused of something, these are all the rights that we have as American citizens. And one of those is to be informed of the nature and cause of the accusation and to be confronted with witnesses against him. So none of this business that you have going on with what these Child Protective Services do. That's totally bogus, totally unconstitutional, flatly illegal. Now, I've had some families in my church one of whom spanked a child in a restaurant. I mean, he took the child into the bathroom so the spanking could be done in private. It was done in a completely appropriate manner. The child was misbehaving, needed to be disciplined. That's what the father did. Somebody barged in on him in the restroom and accused him of child abuse, which of course it was not. And so he was pretty shaken up by this thing. And I said, look, if you have anybody come to your door representing Child Protective Services or law enforcement, do not let them in the door. If they do not have a warrant signed by a judge, don't let them in the door, because Child Protective Services could come in based on this anonymous complaint from somebody you've never seen before and take your kids away from you, so don't answer the door. To have compulsory process for obtaining witnesses in his favor. So that's where you can issue subpoenas. You've got somebody that has information or testimony that can exonerate you. You have the legal right to compel them to appear. They can't hide. They got to come and tell the truth under oath. And to have the assistance of counsel for his defense. That's the last one of the rights that's listed in Amendment 6, to have the assistance of counsel for his defense. This is the word for a lawyer or for attorney. If you're accused of a crime, you have the right to have an attorney assist you in your defense. Now, notice that that's where it ends. You have the assistance of counsel for his defense, period. It does not say you have the assistance of counsel for his defense and the taxpayers have to foot the bill for your attorney. That's not in there. That's not constitutional. There is no constitutional warrant for that whatsoever. So nowhere in the Constitution is there any sort of requirement that anybody but the accused has to foot the bill for his defense, for his lawyer. None whatsoever. But of course, you got this activist judiciary now. They've been imposing their judicial will, substituting it for the wisdom of the founders time after time after time. I did a little bit of research on this morning and discovered that where this whole thing started back in 1963 is with a guy that broke into a bar and stole some beer. And he wrote a note to the Supreme Court saying, I can't afford an attorney, I need one. He stole some beer. He broke into a bar, stole some beer, and because of that, because the Supreme Court, I guess, felt sorry for him or something like that, now we got to cough up $2 million out of our own pockets to defend those that are clearly guilty of murder. Now, what they found there then in 1963, they found some kind of magical, mystical right that just appeared out of the mist, some kind of emanation out of some kind of penumbra wafting up from the parchment the founders left to us. And this was a right so mystical and so magical and so mysterious that it had escaped the notice of the finest jurists in the United States for 176 years. Nobody had seen this right in the Constitution since 1789. So it just magically, mysteriously, suddenly disappears. Now, I think you got to also take into account human nature here, because I think there's little doubt in my mind, knowing human nature as I do, being a fallen human being myself, I think there is no question that somewhere in the fevered mind of a criminal hovers or lurks the thought that if he gets caught, not that big a deal, he'll get an attorney for free. So there's a deterrent effect in knowing that you or your family is going to have to pay the cost of your legal defense. If that evaporates, thieves now know that they can rip off their victims once and then rip them off again if they get caught. And it's interesting to me, the prison population, since this judicially activist ruling, the prison population in the United States is 10 times bigger than it was in 1963. Why is that? Because we are subsidizing lawbreaking. We're subsidizing it. We're telling potential criminals, hey, don't worry about defending yourself. We've got your back. We've got you covered. Go ahead and knock off the convenience store, knock off the gas station, shoplift that coat because you get caught, you are covered. So got Got a prison population 10 times the size of what it was in 1963. Now, what's the solution here? And I would say the solution is very simple. It's a governor who is backed by his state legislature who says we're not going to comply any longer. It's a governor who says to the Supreme Court, look, I can read the Constitution just like you, and nowhere in there are my citizens obligated by this Constitution to pay for criminal defense attorneys. It's not in there. We are under no constitutional obligation to pay for criminal defense attorneys. And we're going to stop fleecing our taxpayers for this. We're not going to do it anymore. We're going to make sure that the accused has access to an attorney. We're going to protect that right. It's a constitutional right. We're going to be zealous for that. We're going to be jealous for that. Anybody tries to keep that guy from seeing an attorney, we're going to be the biggest enemy he has in the world. So we're going to make sure that they have access to an attorney because that's in the Constitution, but paying for that attorney is not. So from now on, we are going to expect criminal defendants to provide for their own defense out of their own pockets. Now, maybe that would give would-be criminals just something else to think about while they're plotting their next journey into crime. Now, I want to hasten to add, a governor who did this would not be violating the Constitution. He would be upholding the Constitution. He would not be violating the law. He would be ignoring a blatantly unconstitutional and thus legally void ruling from judges who themselves ignored the plain meaning of the constitutional text and committed a second judicial offense by imposing an additional tax burden on the American people. Realize that's what's involved here. The Constitution emphatically does not give to the court any authority or right to raise our taxes, but that's exactly what the court did. You got to tax your people. You got to raise taxes on your people to pay for these defense attorneys. And so far, for 50 years, we have meekly complied. Now, the American people are good-hearted and generous. There are charitable organizations that already exist for the purpose of providing a defense for falsely accused. People will donate if they think the defendant has been falsely accused. They will donate out of the goodness of their heart. You have privately funded firms which provide pro bono representation for those who've had their First Amendment rights infringed. So there are solutions to these problems. Are criminals entitled, in some, by the Constitution to legal counsel? Absolutely. Are they entitled to have taxpayers foot the bill? Absolutely not. Where is the governor to lead us back to the Constitution?